conversation. Two of our guests standing by still with us in Minneapolis, criminal defense attorney Joe Tamburino, and joining us from Columbia, South Carolina, criminal defense attorney John Mobley. John, I'd like to begin with you, please, and pick your brain when it comes to how this case is being defended. I know there's no burden on Stanley Ford whatsoever, and these attorneys so far, they seem to be pretty active, pretty aggressive in some of the cross-examinations. What do you think they need to do strategically to try to help win this case?
Well, I think that this is the perfect defense for what everybody calls KISS. Keep it simple, stupid. I mean, and ultimately, the bottom line in this case is, well, yes, there's a horrible fire. Yes, the prosecution has proved that the defendant had a not so great relationship with his neighbors. But unfortunately for them, and fortunately for everyone else in the country, they have to prove more than that. They've got to prove that he actually committed the fires, and that's where they're just falling short time and time again. So from the standpoint of the defense, it is keep it simple. Focus on the lack of eyewitnesses, the lack of the defendant being clearly visible on the video, the lack of any type of admission by the defendant that he committed the fires, the lack of any statements to the neighbors ahead of time indicating an intent to commit a fire or an arson, and even the fact that the prosecution put up a neighbor that indicated there's a third party, another suspect that had the motive to commit the fire based on an issue with a neighbor, and also evidence that that neighbor actually tried to commit a fire. So I think it's very simple for the defense, and they just focus on that, and they should have a fairly good day.
Considerations in every case for witnesses, for jurors, for defendants, and we've seen some choose to wear masks, others choose not to do face shields. What do you think about his choice to keep that mask on his face through the duration of this trial?
I mean, I don't think that's an issue at all. There's no issue of identification of the defendant in this trial. Obviously, the state of mask and everyone's subjective personal beliefs about mask wearing and getting the virus is something that everyone deals with. So I think that's one of those things that's going to really not have any negative effect on the trial at all. And the previous attorney talked about the prosecution potentially having the defendant remove that mask during the course of the trial. And I just got to say, whenever the prosecutors try to create a Perry Mason moment and do something like that, they need to deliver. And ultimately, that's just not going to happen in this case. That, if they have him pull that mask down so the jury can see his face, they need to do that with the expectation the jury's going to look at the video and say, that is clearly the defendant. But that won't happen because his own neighbors can't say that's clearly him. So I think when lawyers try to, use stunts like that in the courtroom, if they don't work, it's going to backfire on them. And I think a good example of that is when the prosecution in the O.J. Simpson murder trial had him try that glove on in front of the jury, and we kind of saw how that worked out for them.